I will say that the exemption from liability is limited. The state can only exempt cities from state laws. So, you know, if a plaintiff came in and wanted to file a lawsuit based upon federal rights and federal statutes, and typically that's what you see involving municipalities, the exemption under state law would do nothing to prohibit not only filing of that lawsuit, but also if they stated a viable cause of action under federal law from succeeding on that claim. So the exemption from liability in the statutes really does nothing to eliminate all liability which may be expected out there. And a typical cause of action that you might see in such a situation would be a deprivation of due process claim by somebody claiming that their life was deprived due to lack of either procedural or substantive due process. And nothing within the statute would provide an exemption for that. And because that claim is filed under the federal statute, Section 1983 liability, what's even worse is there are no caps to that liability. So under the Kansas Tort Claims Act, for any tort claims that are filed, you have a cap of liability of $500,000 per occurrence. Under the federal statutes, it's unlimited liability. So that's the liability question. Addressing another question that was posed, which is related to liability, insurance. You know, we've been involved. Me and my firm have been involved in the discussion relating to conceal and carry with multiple carriers, multiple underwriters, and a lot of them, I will tell you, are drafting exemptions or exclusions from the policies for those municipalities who are authorizing conceal and carry, basically excluding those cities, any claims which are derivative or derived from a city allowing conceal and carry within their municipal buildings.
What does that mean? I'm not sure I understand what you're talking about there.
Basically, they won't cover us. The city would pay.
Right.
Wait a minute. If you're saying the cities that you work with, say that part again, if you would.
No, it's not cities that I work with. We've been in
other
contact with underwriters for underwriters, and underwriters have actually been in contact with us because of our ties in with the municipal community, and asked us for information about conceal and carry so that they can develop their policies. And those carriers that we've been in communication with have indicated that those municipalities who allow conceal and carry, that they'll have exclusions under their general liability policies for those municipalities that allow conceal and carry. So in other words, it wouldn't be...
They wouldn't cover us if there was an accident,
right.
If there's an incident. Okay.
Real quickly, I know it wasn't that long ago that your firm made their presentation to City Council here prior to your appointment, but how many cities does Maganani, Van Cleve, and Phillips represent across the state, and school districts as well?
I think we represent, I think it was about 25 different cities and school districts. I think it's 100 and some school districts across the state of Kansas.
Okay.
So, one other point that I wanted to respond to in response to Councilwoman Harrison's questions about employees and restricting employees. I think it's worth noting, because I'm not sure it's entirely clear, that all of the options that were presented, options A, B, and C, talked about restriction of employees in conceal and carry in the workplace. And the statute, that was the law before House Bill 2052 was passed, that you could restrict through personnel policy, both restrict and prohibit conceal and carry in both private and public workplaces. The new law continues to allow public employers to restrict public employees conceal and carry in the workplace, even if you allow conceal and carry in your municipal buildings. Now, restrict is obviously different than prohibit. options A, B, and C are not all the same with respect to prohibitions on prohibiting your employees from concealing carrying in your municipal buildings. If you take down if you allow conceal and carry in your municipal buildings, and you, and so that's basically option B, you can continue to restrict employees, basically spell out how they can conceal and carry in those buildings, but you cannot prohibit them from carrying in your buildings. So I wanted that distinction made clear.
Can I ask what kind of restrictions would you see being imposed?
You know, we've talked about several, and Greg Goheen, a partner of mine, I think presented at CARET, and I think the chief was there. He talked about, you know, requiring employees to carry their own insurance. Really obvious restrictions would be, you know, don't display your weapon openly, ensure it's, you know, adequately holstered at all times, things like that. But it could be broader than that, and you know, the statute doesn't define what restrictions you can place on it.
Does the liability change, is it, if we restrict employees, but let's just say we allow them to carry, but put some restrictions in place, you can't show it or what have you. If there is an accident or a purposeful event that happens, does the liability to the city, is it different if an employee does it versus a person from the public who comes in with a conceal and carry?
It depends on what the event is. You know, and the reason I say that is, let me give you an example. The example that the chief gave, in that the employee who has a conceal and carry permit, and I'm not sure I'm going to directly answer your question, so if I don't, tell me, please. But if the employee that has a conceal and carry permit, you've removed your stickers, they have an accidental discharge and injure themselves, okay? Now, presumably under the state statutes, that there would be an exemption for that from a workers' compensation claim, because you're exempt from liability associated. I mean, the argument that would be made is, well, this is directly related to the employee concealing and carrying in the workplace, so that exemption under state law should be applicable to the workers' compensation claim. If the facts of it are changed to where, and really a work comp claim is the only thing that would probably be cognizable there. If the facts were changed to, say, you had a clerk that was concealing carrying, they rightly or wrongly perceived some threat by someone in the public out here, they pull out their conceal and carry weapon and discharge it. Well, at that point in time, you would have immunity under state law, but again, now you come back to that citizen having rights federally under Section 1983 to come and file a federal action for which the state exemption would not apply. And did I answer your question?
You did.
Okay.
So that really means that it's a wash from the exemption standpoint on the basis of the federal lawsuit, the deprivation of life. In other words, if we decide to go with the 4-year exemption, which you say is not something that exempts us from being sued, it doesn't matter. I mean, we face risk on either side. That is, somebody that says you didn't adequately protect me because I couldn't carry my weapon, as well as somebody on the inside saying you allowed a weapon to be used by an employee, perhaps, or even by another person that walked in, another patron. So really, that point kind of seems moot, really, because you have a wash there of equal risk.
Yeah, and that may well be. You know, plaintiffs' attorneys become very creative. The only thing I would say is that if you